the first to know. Nsem-Pii TV.
The Chief Justice, Madam Gertrude, her ladyship, Madam Gertrude Tokonu, filed a special writ to the ECOWAS court in Abuja, or seeking for judgment from them based on trial, calling for the suspension and removal from office as Ghana's Chief Justice. Now, some comedian also Abuja courts, betinase, ECOWAS court betinase on this case. Now, share case free the Supreme Court of Ghana, free various judicial reviews at the Supreme Court of Ghana, even were calling for judicial reviews at Supreme Court of Ghana based on initial injunction and not order to investigative committee, Justice Powerman Committee, no more they should share in Nsem-Pii. Now, who said, to me, nya justice from the Supreme Court of Ghana, and intina or hearing or call to the ECOWAS courts in Abuja. Now, breaking story and Saka, chairman of Constitutional Review Committee, Professor Prempeh, Professor, Chair of Constitutional Review Commission, and member of Advisory Board of Africa Judicial Independence Fund of Afro-Barometer at the Nsem-Pii Atudra. Professor Prempeh ena yepesi de bremo no or say as part of Constitutional Review Committee major recommendation or deba say President Mahama and say any other president I be take over the presidency of Ghana no omo yi sa powers no ebe mano the authority and as a power so betimayi any chief justice in future. Omo hwe the nsema ekoso ene ya omo say constitution of Ghana ma President Mahama powers na abo Ghana kapa because it doesn't make sense say a president be manisa powers and so obetimi eyi chief justice of the same republic because so odi assembly na etiana ana odi assembly na etia the executive and the government in power ebetimi ayeden akoso ni removal because the president na ewo such powers. I say yes, setting up an independent review. Now no crowd say okoshe Kenya emra ewo Kenya ne say omo person mo yi chief justice nimpoa enye justices of the Supreme Court omo te bench no so and etena sa case no so because obi any was certain argument ni differences ebetimi ayeden influence the judgment into omo kohwe even retired judges, independent retired judges and ebetena cases so say retired judges ni ho a omoma kwan ma Kenya for ekope Commonwealth countries omo African countries so omo judges omo betena case no so because omo yeden independent yentimi influence so two changes and Professor Prempeh, the chairman of Constitutional Review Committee, proposal one. Say be president. Now the president Mahama, ye be sa powers ne free in him. So obey me a chief justice. Or say it doesn't make sense. And now two, because presidents no omonye angels. And now two, so obi person mu ye chief justice in poa. Nye justice of the Supreme Court or te bench and so. And as form an investigative committee. I decide on the case. Yes, the recommendations about not retired judges and it's not case so. So retired judges in New Commonwealth countries, to say Kenya, to say Nigeria, omuni Ghana share the same common law. No, obetimi the judges naba no matter case with an independent mind, not influenced by politics. And no decide. You go to Professor Prempeh, you are near lawyer Bafu in some of the faso the Chief Justice Gertrude Tokonu in as much as or the case akodom ECOWAS courts in Abuja.
So again, from guidance of Madam Kasati, my first question is: should the president be removed from the proceedings for removal of the Chief Justice which applies to constitutional bodies. 2, should what is your comment on the presser of the Chief Justice in terms of irregularities and things she finds to be illegal at the committee? And 3, should we relook at in-camera provision under Article 146 of the 1992 Constitution?
Those things. Should the president be removed from the process? Absolutely. I think going forward, it's not healthy, right? It is a temptation. You don't tempt power in these parts like that. Certain things we have done with our constitution almost presume that the people we are going to elect are angels. I mean, it is one of the most ridiculous. Our constitution is too permissive. It trusts power holders too much. Whether they are the president, they are the chief justice, we trust people with power too much. So there are almost no restraints on anybody with power in this place. You know? And whenever you say the president shall do this, the president in Ghana, I mean, shall sometimes, in some places, shall is a duty. Right? So in Kenya, the president appoints the judges. But it is understood as a duty to appoint once the Judicial Service Commission has nominated them after going through an interviewing process and they've come up with a list. You just have a duty to take it to Parliament for them to approve. And once they approve, you have a duty to appoint. In Ghana, you say shall. Hey, that's my power. It is, I shall appoint you. So I do the thing by myself. Absolutely, the president shouldn't be given that kind of power. Whether in the appointment side, on the appointment side, or on the removal side. I don't see the point, right? I mean, and then you have other things like the sitting justices on the Supreme Court, your peers, must now sit in judgment upon you in an in-camera proceeding. Why do you think the Kenyans, when they got there, said no? Go for retired jurists. They know, they've experienced these things before. So the Kenyans, the same removal provision in another common law country. So no, when it gets to that point, go and borrow some retired judge. Or if you can't find any, actually go to the Commonwealth countries and find one. Find 1 or 2 or 3. It's in their constitution. Very Pan-Africanist. They say you should go to the Commonwealth Africa and go to Ghana and bring somebody to come and sit in judgment on this case because this person's peers on the same court. We don't, even if they will do justice, we don't want the collegiality and everything to be wrecked. So leave them out of this. Actually, reaching a flawed constitution like that, and then now that is being applied, we are all up in arms. Why is it in camera? Why must justice be done in camera? Right? I mean, so I don't understand the point of it. It's a national security issue. Initially, they said it was for the protection of the institution so that they are not washing their dirty linens in public. But this kind of opacity doesn't help anybody. You know? So when this matter came, my first comment on it was, look, even if it's in camera, if the proceeding itself is in camera, we must at least be open to everything being published after the fact. Because I can't change the constitution at that point, right? I cannot read the constitution and say that this is just best practice. It's not in the text. I don't think that is a proper reading of the constitution. It is there that it must be in camera. So for now, it's in camera. But why can't we at least agree that after the fact, the in-camera clause or provision or text does not stop us from publishing, the judgment. Maybe not the proceedings because it would defeat the in-camera idea, but at least the judgment and the reasoning. Okay. Nothing like that is in the Constitution. It's not required. Nobody says we should publish anything. Right? So I think, it's a bad situation. I mean, I'm not particularly sure there is a whole lot we can do about it. But I think going forward, we must fix it. There is no reason why we should have a system like that, because when people come here and they are surprised that our electoral commission is choosing the way it's choosing, and we still trust election results. This would never, many places would never accept it. That the president can just pick any 3 people to constitute the commission, or 3 or 4 or 5, and the other people accept the results as fair.
You should respond to this in a more detailed manner than you have responded in your comments. And so go to the committee and answer it. But that makes it necessary extremely important for the president to inform the Chief Justice whether or not the prima facie was established in respect of all the complaints or parts of the complaint. From the Chief Justice's account yesterday, she doesn't know which part of the complaint that the prima facie case was established in respect of.
But she asked the committee.
Paul, she doesn't have to ask the committee. If you go to court, it is a quasi-judicial process. If you establish a prima facie, in setting up the committee, you have to put me on notice that of all the issues that were brought against you, we think that as for this one, you should answer them. Don't forget, under the Constitution of Ghana, if you are a judge, you have some immunity. Under Article 127, those immunities are provided to ensure that judges can do their work in freedom without fear or favor or ill will. So they are there to protect judges. Some of the complaints that have been brought against the Chief Justice, right, are in respect of his work sitting as a judge, president of the Supreme Court, right, in respect of some of the matters that she sat on. And so if you have established a prima facie case, is it in respect of the complaint that concerns her work as president of the court in specific matters that she sat on, or other matters which are totally unrelated to her work, her work as a judge, but administrative duties? But you have to make her aware. Let me tell you why it is important you have to make her aware. In coming to the committee, there is a burden of proof. You see, not all cases requires that the petitioner must prove. When an allegation, for instance, is made in the negative, but the burden is rather not on the complainant, it's on the Chief Justice to prove. And so if you make allegations against the Chief Justice and the President has found it necessary to say that I've established that there is a prima facie, it is important for you to let the Chief Justice know which of the complaints you have established the prima facie. That makes the Chief Justice, that puts the Chief Justice on notice, makes the Chief Justice prepared, right, in coming to answer it. But the most bizarre thing, which for me is sad, is that whereas the Chief Justice has not been told which of the complaints a prima facie case has been established, some government communicators have spoken extensively on this matter in the media
About the prima facie,
taking the complaint, the petition, and stated that in respect of some of them, the President established prima facie. In respect of others, there was no prima facie. So if the person who is going through this process does not know, right, which of the complaints a prima facie case has been established, but government communicators know about it, is it fair? It is not fair. And so for me, in my humble opinion, right, it really undermines the integrity of the process. And it is very sad that the Chief Justice of the Republic of Ghana should be going through this. No matter.
So without that, I thought that would guide the committee's work. Is that not what? So she goes and they say that there are 3 petitions against you. Petition number 1 is from Paul Adumochi. He says that you don't come to work early. And the President has seen the evidence of Paul Adumochi, has seen your response, and thinks that you should explain yourself to the committee. Without that, what process are they going through?
Paul, and that is what makes it bizarre. And so without further information, I am saying that what is happening undermines the integrity of the process. It casts the whole process in a certain light, right? That makes it seem not to be genuine. It appears that people are using the camera or the secrecy of the process to achieve a certain end without more. And that is why it is important for the issues that the Chief Justice has raised to be answered, particularly the absence of notice to the Chief Justice as to which part of the complaint or the petition a prima facie case has been established on. without more, it really, really, really casts serious doubt on the integrity of the process. Look, I understand that the procedure which is being used or has been borrowed is the civil procedure rules.
Yeah.
And the Chief Justice thought that they should rather use the commission of the procedure, designed for commission of inquiries. I understand, I saw Mr. Tadiosori also, raising issues about the Chief Justice's position.
Yes.
As much as the committee is free, together with the parties, to agree as to the procedure to be used, right? I think that the commission of inquiry is analogous, and that for me should be preferable to the civil procedure rules, which is an adversarial regulation of our courts, adversarial regulation or procedure that regulates litigation in our courts, which is why the Chief Justice is saying that the whole process is very adversarial. My brother, even employer-employee relationship, right, matters relating to employer-employee relationship. When there is a hearing, when you go, you are told exactly why you are there. You are told exactly why.
So she's not being told. That's why she's talking about Nebuchadnezzar?
Yes, because a petition has been filed. That petition, right, there are 3 petitions containing various complaints. Those 3 petitions, right, the president says he has established a prima facie case on. The duty was, the president and the Council of State have established a prima facie case on. There is a duty, a legal duty, to inform the Chief Justice whether the prima facie case was in respect of all the 3 petitions or parts of the petitions.
So she will know how to prepare?
It's a basic principle.
So she's being tried in the dark?
She's been tried in the dark. It's the basic principle of the rules of natural justice. I have to know what I'm up against. It helps me in preparing my case. It helps me in knowing the burden on me in terms of the evidential burden. It helps me in putting together my evidence. It helps me, right? Even in the Garden of Eden, when Adam, right, went to eat the apple and God appeared and they said, and he asked them, Adam, what have you done? He gave Adam the opportunity, right, to answer for himself. That's the rules of natural justice. You should put the person on notice, the nature of the case you have against that person, which is why in civil litigation you file pleadings. The pleadings comes to you, you have sufficient time to prepare your case. That is your defense. Okay? In criminal law, in recent times, in the case of Martin Pebu versus the Attorney General, the Supreme Court has held that disclose all the evidence you have against the other side, so that based on it, the person will prepare his or her case. Okay? I think that it was, that underpins, that philosophy underpins our justice administration system. It is to ensure fairness, so that nobody is ambushed. I mean, think about it. The Chief Justice is undergoing through this process in camera, where from her account, she's not even allowed family members or witnesses to come along. Even in employee-employer relationships, when you are going for disciplinary hearings, you are asked to bring a friend to witness what goes on. So why are we doing this? If the Chief Justice's account for me is true, without more, I think that the integrity of the process is significantly undermined by what we are saying, by what she has said. And something has to be done to remedy the situation. A lot of the things she said, for me, are sentimental, right? I think that the government can, in the spirit of fairness, address them. For instance, if it is edu law she's not comfortable with, government can assist by providing an alternative venue. I think, for instance, that in respect of those issues, the Chief Justice could simply have written to the government to express her concerns. And if they had not been addressed, then she could have stated them in her press conference. And so for me, the complaint in the press conference in respect of that, for me, could have been handled in a better way, differently. Yeah. But in respect of this matter, how many times haven't we talked about this prima facie and the need to give the Chief Justice notice of what constitutes the prima facie? President Akufo-Addo, when various complaints have been made against, petitions have been brought against previous Chief Justices, Chief Justice George Wood, Chief Justice Sophia Kufu, Chief Justice Emily Ebua, in all instances, when he deemed that there was no prima facie case, did not just write to the petitioners and say that there is no prima facie case. Professor Kweku Azar, he had petitioned against the Chief Justice, and the president didn't just simply write to him and say there is no prima facie case. He gave reasons why there is no prima facie case. He went over and above himself. And I don't know why, in this instance, the Attorney General, Dr. Dominic Ayini, is looking on. I think that the nation needs explanations from the Attorney General, for instance. He is the only one whose office is guaranteed under the Constitution of the Republic of Ghana. He's not there for any reason apart from making sure that the president and other people who are acting together with the president, and in this instance, the Council of State, work in accordance with law or act in accordance with law. I think that Dr. Ayeni would have to explain to the nation if what the Chief Justice came out to say is true. Dr. Ayeni has a responsibility as the Chief Legal Advisor of government to explain to us if what the Chief Justice is saying is true. Don't forget that under the laws of this country, all human rights actions, the Attorney General is a party. It's not a coincidence. It's because there is a burden on the Attorney General to defend the fundamental human rights of people, right? Mm-hmm. And so he has to explain to the people of Ghana whether the complaints of the Chief Justice is true. Because the Chief Justice of the Republic of Ghana is being denied fair trial. That is what it is. It's being denied fair trial. So Dr. Dominic Ayeni owes us an obligation to explain to us if it is true. If it is true, what kind of legal advice is he given at this time? Right? What kind of legal advice is he given? We need explanations. Okay? This 1992 Constitution, I keep saying, we must reap the fruits of the Constitution, Paul. And so for me, this information...
But as people have written on social media, these are the same matters she put before the Supreme Court and she was denied. The Supreme Court dismissed the action.
No. The Supreme Court dismissed the action.
Yeah, they did.
And they said because it was in camera. Mm-hmm. It is out of that frustration that she's out here complaining. Mm-hmm. I am saying that when you look at the issues that she took to the Supreme Court, right, it was the petition, it was the supplementary affidavit which she filed, which basically she was putting out those complaints. The Supreme Court had deemed that not to be relevant to the matters before them because they felt that that was not the forum. The reason why she was there was different from the reason why the basis for the supplementary affidavit. Mm-hmm. That was perhaps the reason why the Supreme Court took that position. It doesn't take out her right to fair trial. She's entitled to fair trial. All the issues she's raised, as I've said, most of them are sentimental. But the issues as to lack of sufficient information on which of the complaints a prima facie case has been established on is so fundamental